understanding of rights, public, private, penal, and procedural. He lays some of the shards on the table, and many of the jurists who work under his inspiration in the next couple of generations start working out the consequences of some of those theological ideas. And there's another book by my wife's husband that I'd recommend called Law and Protestantism, where I kind of lay out that jurisprudential story a bit more fully. Luther does not view rights as contingent upon the proper discharge of duties. That is, if you don't discharge your duties, you don't deserve rights. Luther would start with the proposition that rights, in the sense of being fundamental rights, are God-given gifts to all humanity, undeserving humanity. They're gifts, he says a couple of times, of grace, and the basic rights that we enjoy within the family, say, a husband and wife with each other, parent and child with each other, the basic rights that we have to property and the fruit of our labors, the basic rights that we enjoy to having our contracts and promises enforced, the basic rights that we have to inheritance and post-mortem support, basic rights that we have to vote and to receive what he calls due process. Those basics are given in human nature and not dependent upon a person's dutiful discharge of every prescribed duty that is set forth in Scripture or in the moral code. As we begin to watch the evolution of rights talk in its Protestant guise in the early modern period, the question about rights shifts increasingly to a question, back to our earlier questioner, about how do we justify the right to resist and revolt a tyrant. And the question becomes increasingly, what rights are so fundamental, what rights are so inalienable, that if chronically and pervasively breached by a tyrant, they trigger the most basic right of revolt, of revolution, of regicide. And in answering that question, Protestants spend time beginning to spin through the Scripture and spin through the tradition and start thinking about what rights are fundamental, what rights are contingent. And they start, as Luther started, with the Decalogue. We have to obey God. The right to obey God, the right to honor God, the right to worship God has to be fundamental. Is the right to obey God's law encapsulated only in worship? No, it's to abide by the second table of the Decalogue as well. And then on they go, developing different ontological foundations or templates upon which they build a theory of fundamental rights. And you watch over a century the evolution of that, and pretty quickly they begin to think through what the implications of duties and rights with respect to life, with respect to property, with respect to the marital household, with respect to reputation, with respect to procedure, with respect to religion are fundamental. And you watch the evolving tree of rights that emerge from that early distillation. And all of this is in place before the Enlightenment liberals ever begin to work on questions of fundamental rights. And they're there in the tradition. And they're bracketed and they're formulated in different ways, but they're parts of the tradition. And they, in fact, are drawn in part from medieval canon law and from Christianized Roman law as well.
Okay, thank you. Okay, over there, a question. Yes.
I think you all should go to Andong Law School. It sounds like it'd be a good thing for all of you. And I think the dean would be happy to have you. He's just told us he's waiving tuition, so I think it'd be good for you. It'd be good.
Hello, my name is Tom. Thank you for the lecture first. Professor, I'm aware that you have not exclusively mentioned anything about practical adaptation of law in this lecture. But I know it's off the point of this lecture, but as a Korean citizen, could you tell us your thoughts on recent nullification of adultery law in Korea as a marriage law expert and a Christian?
Recent nullification of adultery law in Korea as a crime? Yeah. Well, it's a sad first step into sexual liberty run amok. It's interesting that in the Western tradition, Greek Hebrew, Roman, Christian, Enlightenment, post-Enlightenment alike, that adultery has always been viewed as a fundamental betrayal of the most primary institution of society, namely marriage. And that all through the tradition there has been a consistent set of logics that say that adultery is not only a private harm done to one's spouse and one's children, if there are children, but adultery is also a fundamental betrayal of the institution of marriage and the society that depends upon the institution of marriage. And while one can prize sexual liberty and one can think about sexual autonomy and the keeping the bedroom from being under the malevolent eye of a police state, this is not nearly as glib as that. This is a fundamental betrayal. And I, for one, find it unfortunate that in the Anglo-American common law, adultery has not been subject to criminal sanction, though it's been on the books in some states as a dead letter for an awful long time. But adultery increasingly is just viewed as a private harm, and a private harm that may well result in further alimony payments, may result in restrictions upon child custody and other consequences for the adulterer or adulteress. But I think that underappreciates the reality of marriage as a both private and public institution, and that the public institution of marriage is a critical part of its phenomenology in any kind of organized society. And as a consequence, a fundamental betrayal of that institution is both a private and a public harm. And signifying that in criminal law, I think, is important. And the law there plays not only a deterrent responsibility of deterring parties from that behavior, but it also properly plays a retributive function in recognizing the harm done to society by the adulterer. And it invites a rehabilitative function, a teaching function, where that party can, upon being duly convicted, find responsible ways by which he is brought or she is brought back into community. And I don't think we have to stone adulterers and adulteresses anymore, or hang them, or torture them, or do a lot of things that we historically did to them. But I think there is a fundamental teaching moment that's lost when a society begins to look lightly on such a fundamental breach.
Yes, please.
Please.
All the way down. Here, in front.
Fire away.
Hi, Philip. Have you come out of this?
Could you introduce yourself first?
Hi, Jin Ha Kim. I studied at Calvin College for the first 2 years. I transferred to Handong.
Not now.
My question is, what do you think, or what would Luther think about same-sex marriage as some argue for human rights?
What do I think about it? Not much. I think the more important part of your question is that you left Calvin College. How could you leave such an august institution? Great reform learning to come here, another august institution of great reform learning. So you have 2 good years of you anyway, and it informs your good question. I don't have anything terribly original to say about same-sex marriage that you haven't heard before. I'm against it as a right. I think it's a betrayal of the fundamental definition of what marriage is about. I think it betrays the fundamental purposes of marriage that have been understood in tradition. And while constitutional laws and liberty calculus in particular has increasingly moved toward this precipice, I don't think it's a necessary next step of due process or equal protection jurisprudence. And if I can trot out all the arguments that you've heard before, but I can stand in tradition on this one. And it doesn't mean that I think that sodomists should be hung up by their testicles, as historically we did. It doesn't mean that we have to pillory those that feel naturally inclined toward a gay and lesbian inclination. Those who are naturally inclined toward a gay and lesbian life, those people should not be stigmatized. They shouldn't be ostracized. They shouldn't be excluded. But they have a natural inclination, which, in my view, cannot be responsibly expressed in a state-sanctioned relationship. And those that choose to express them, in my view, do not have a right to continue with that, and the Constitution should probably protect. That's just an old-fashioned Calvin College guy. But you probably recognize all that.
Okay, now, Enoch?
Then as a follow-up to that question,
You're dealing with explosive topics now, I guess.
then as a follow-up to that question, how can we then practice law if we want to be law practitioners, but also maintain our Christian values? If the world says that we need to follow the laws, such as gay marriage or adultery.
So you can choose another profession, or you can work. I mean, maybe our friend Martin Luther can help us here. I mean, Martin Luther talks about the meaning of a Christian vocation atop the two layers of responsibilities that we have already, that I described to our colleague who asked the prior question. And then he said, some people are called to particular vocations, which vocations require them to do things that they would not do in those two layers of responsibility below. And Luther says this in the context of being a soldier or being an executioner in a capital felony case. And Luther says you may feel called to be a soldier. You may be called to be an executioner, and your job is to be the very, very best soldier and the very, very best executioner that you possibly can be. Your additional job, says his founder, his successor, Philip Melanchthon, is that you, to the extent you find that that vocation pushes you into moral dilemmas, dilemmas of conscience, forces you to violate your own faith commitments, your job is twofold. Number one, either to flee and to take up another profession, or number two, to seek, by being inside, reformation of that vocation in a direction that is more congenial with the belief system that you bring to it. And to bring it in conformity with Scripture is amongst the obligations that a party can seek. And in this case, we have an interesting correction of Luther's starting point, which is jurists are bad Christians. And Luther started with the idea that jurists really cannot be Christians. It is too much betrayal. And in the end, he eventually, by 1526, 1527, he began to realize that jurists are actually pretty good Christians, and many good Christians can become jurists, and that law is a necessary feature of any enduring and resilient reform. Even though it comes with compromise, even though it comes with difficulties, and even though it forces people to do things that they would not in their private relationships, in their family relationships, or their church relationships do. And so when you're in the business now of becoming a lawyer, which I commend all of you to do at Dean Enlow's law school, what you do is you prepare yourself first and foremost for being a good lawyer. And you do that with humanity, with compassion, with humility. You do that within the constraints of what the rules of ethics allow you, let alone the rules of law. You take the opportunity when it's given to you to witness to your faith. You work to the extent you can to reform those laws whose current formulations you are obligated as a matter of choice, a matter of course, to enforce. And you work to the extent you can within this broken but nonetheless still important institution. And that is the obligation that you can discharge, you must discharge. You can recuse yourself as a judge. You can sometimes refuse a client. You can certainly make selections within the legal profession that do not force you to have those dilemmas of conscience. There's plenty of room whereby the legal profession makes space for folk like you and me. But there is ultimately an obligation to discharge that vocation fully. And those that don't need to get out.
Okay. We have still some kind of 15 minutes.
I got a lot more than 15 minutes in me.
By the way, Professor John Witte is also Dutch. That's why he's so tall. From Calvin College.
Genetically
Professor
selected.
Nicholas Lanting. Maybe he's a little bit lower than Professor Lanting. I don't know.
My forebears lived under the sea. And so anybody that was short when there was a storm was washed away. And so it's a peculiar form of Dutch Darwinianism that only the tall survive.
You can ask any other questions in Christian life. Yeah. Okay, Kim Chan?
You want to have
Hello, my name is Ching Chen. I don't know if it's comprehensively prepared yet, but I've got the news from your response to her that the American legal system is well established and founded on that godly divine due process that God shows in the Genesis, that the legal system, it safeguards that liberty and that due process that God protects and endows upon human beings. But what I thought was surely in human effort to apply that divine due process into our legal structure, there must occur some discrepancy, some limitations, some distortions into interpreting that and fully putting that into our legal system. So my first question would be, what would be some of the faulty aspects of modern legal system when we reflected upon the scripture? And secondly, if we do recognize the imperfections of the legal system, would it be biblical for us to comply to that or that faulty structure instead of obeying a higher perfect law set by God?
That's a big set of questions. Let me just focus on the due process part of how the modern legal system reflects or doesn't reflect the lessons of divine due process that Luther ascribed to God's understanding of judgment. What Luther was trying to do, and what a number of late medieval mystics on whom he relied in part were trying to do, was to say that implicit in the office of political authority is the responsibility of judgment. Making judgment is an indispensable part of lawmaking and law enforcement, and that the judge has to discharge a discrete office within the office of the state. And he's pushing on that first starting point. Secondly, he says, look, if you're going to be a Christian judge or try to be a Christian as a judge, what are some of the requisites that you have to take into account? And he then rummages through Scripture to talk about, well, the moments of judgment that we see in Scripture, from King Solomon and the issue of dividing the baby to the various iterations where God calls his people into judgment, and the perennial invitation and threat and hope of true divine judgment on the day of judgment. Luther gathers all those into an idea that, look, there is in the office of the judge, in the delivery of a just judgment, a fundamental responsibility of doing requisites of what we would now call procedural due process, putting in place a set of rules about pleading, representation, defense, opportunities to be heard, and all the other incidents of what we call procedural due process today. And it's that level of process that he is thinking about as he tries to habituate a divine lesson into earthly law. The modern formulation of due process does have a procedural due process aspect to it, but it has also now become an invitation for an open door of pouring values called substantive due process rights into the legal system, and doing that on the strength not necessarily of democratic ventilation, but on the strength of judicial lawmaking. What gives people pause is that due process has now been mangled into something very different from what it originally was understood to be. What does then a person do? And that was your question, the question of your colleague right before. If you take the oath of office, as a judge, you now have a peculiar vocation that you have chosen. Your job is to uphold the law of the United States, the law of the Republic of Korea, the law of whatever jurisdiction you're in, and to maintain that law. Again, doing what you can with all the virtue ethics that attach to that office. But your job is to uphold and maintain the law, which includes abiding by some of the substantive due process norms that courts and legislatures have put in place.
If it's not
Yeah.
too impolite of me, may I ask?
No, you're not employed at all. You're pushing it.
In the case that those two are in conflict, the oath that you take to abide by, or the personal law that you should follow, when those two are in conflict, then what would you do? What would you
Well,
advise?
I mean, there are expedients along the way of recusing yourself. There are opportunities informally to hand your case to another judge. There are ways of avoiding a certain number of cases that come to the bench on which you sit with a long number of other judges. And increasingly what folk are doing on some of these hard questions are finding ways by which judges, not by random selection, but by choreographed selection, are not pushed into cases that they really can't in good conscience sit on. But your ultimate choice becomes, if you find that the office of being a judge, like the office of being a lawyer, deprives you of your fundamental responsibility to love God and love your neighbor as yourself, your job is to resign.
오케이. 이제 마지막으로 한국어로 질문하고 싶은 학생들 있으면 좀 기회를 줄 수 있으니까요. 난 영어 자신 없어 하면 한국어로 해도 됩니다. You can also ask your questions in Korean if you want. You all want to ask Korean, or Mita, you want to ask in English? Okay? Okay, him first. I will give you as much as I can, okay?
Hello, Professor. My name is Joseph Wang. Thank you for your lecture. You mentioned that as a earthly citizen, duty to obey law of this world, such as structures and strictures of ecclesiastical and political or parental authority. But in your point two, however, in my opinion, in my point of view, the history of humanity is a constant fight and protest against such authorities, trying to find the best model of law. And I think these days it seems that humanity has agreed that current